Hey guys, welcome back to Reddit r/LegalAdvice. What would you do if strangers showed up claiming they now controlled your property, banned your pets, and slapped you with a $2,000 fine even though you had specifically bought in a non-HOA neighborhood? That is exactly what happened to me, but when they threatened my home with foreclosure, I unleashed legal hell on them. And the first one is titled r/LegalAdvice, Insane HOA Bans Pets, Issues $2,000 Fines to Everyone. Throwaway because my wife says I overshare and I don't need this tied to my main account if this turns into a court thing. I also know you folks need details, so I will try to keep it factual and not just rant because I'm genuinely looking for legal advice here before I make a mistake. I live in a single-family house that I bought outright a while ago. No mortgage, it's an older neighborhood that predates all the master plan stuff. When I was shopping, one thing I was very clear about was that I did not want to be in an HOA. I have lived under an HOA before, never again. So I specifically asked my realtor for properties without a homeowner association and verified with the title company that there were no recorded covenants, conditions, and restrictions. I also read the deed, there's nothing in it about any association. The street has a mix of folks, some new construction from a developer on the adjacent land, some original ranch homes like mine, and a lot of folks with normal yards and a dog or two. My wife and I have 2 dogs, both rescues, both not aggressive, fully licensed, vaccinated, microchipped, the whole deal. They spend most of their time inside except for walks and supervised yard time, no excessive barking. They are basically furry throw pillows that live for treats and naps. About 2 months ago, a flyer shows up on my door that looks like it was created in Microsoft Word by someone who just discovered bold fonts. It says, and I'm paraphrasing, that our community voted to join the, censored for anonymity purposes, HOA, which is the association for the new development that went up behind us, and that as part of community standards, all pet ownership is banned except 1 approved fish or turtle per home, effective immediately. Yes, a fish or turtle. I thought it was a joke. It also says the HOA is assessing a $2,000 community compliance levy to fund initial enforcement and legal fees due in 30 days with a $200 a month late fee. I honestly thought it was a scam or something. It had a Gmail address and a PO box, no phone number. It also had a line that said, "No opt-out allowed." I laughed and recycled it. A week later, I get a certified letter. This time, it is on letterhead and it looks more official. It is from the HOA with a management company name at the top that I don't recognize. It says I'm in violation of CC&R Section 9.1, no pets, and I owe $2,000 for the levy and $150 for an initial violation, payable in 10 days. It references my address, full name, and parcel number. My stomach dropped a little because that means they did enough homework to pull records. I am not in an HOA. I know I am not, but it felt intrusive and aggressive. I read it 3 times. It also says that they will place a lien on my property if unpaid and that continued violations may result in civil penalties and legal action up to and including foreclosure. Yes, foreclosure over dogs. I know an HOA can theoretically foreclose for unpaid assessments if you are in it, but again, I am not. I emailed back the Gmail address and I wrote, I'm not a member of this HOA and my property is not subject to any CC&Rs. Please stop contacting me. I got a reply from someone signing as board president. The reply amounts to, your street was annexed at the last meeting to join and majority voted yes. Therefore you're in it. Pets are banned for health and safety. It claimed that there was a general notice sent last year and that silence equals consent. Said no one ever. It also said that I had apparent dogs visible in the yard, so I needed to comply or face consequences. I asked for copies of the recorded CC&Rs that apply to my parcel and any annexation documents. The reply was short, not your concern. We don't share board documents with hostile parties. That set off every alarm bell. If this was real, they would have to have recorded documents, right? Annexation doesn't work by sending a flyer and taking a show-off hands vote. You cannot make me part of your HOA by wishing it so. I called the county recorder. There's a recorded CC&R for the HOA development with the new track numbers behind me. There are amendments for that development and there's nothing recorded that touches my parcel. The recorder said, if it's not recorded against your parcel, it is not binding. The title company who handled my purchase said the same. I wrote the board again and asked for the management company contact. I got a brusque reply saying, all communications must go through the board. Payment portal link is on the website. Well, the website is a Wix page with clip art. I did not click the payment portal. I instead wrote a formal cease and desist letter and sent it certified referencing my parcel and demanded any further contact be via my address only and any liens or encumbrances would be fraudulent and pursued as such. I also told them to put me on their do not contact list because I'm not a member. 2 days later though, someone taped a final notice to my front door. It had a blurry photo of my 2 dogs sniffing around our azaleas and an orange open violation sticker. It threatened a daily $50 fine. My wife was really upset. She is conflict avoidant. I'm conflict avoidant until someone tries to bully me. I walked over to the new development to see if I could get a feel for who was behind this. It's like a different planet. Identical beige boxes, identical mailboxes, identical tiny sad trees. I tried not to judge. I saw a sign that said HOA meeting Tuesdays, so I showed up. I introduced myself and said I got notices and that I'm not a member. The board president is a guy in a polo shirt and boat shoes who looked very pleased with himself. He said, if you live here, you're under us. We expanded the boundaries. You will find it's better for property values. We've already banned pets, RVs, lawn ornaments and exterior colors other than sand, dune or bone. I said my house is blue and predates the development. He smiled like a shark and said, grandfather decorations are at board discretion. I said, I asked for the annexation documents. He said something I will never forget. We don't have to show you anything. If you don't like it, you can sell. A couple of other board members stared at their papers. One woman whispered that they would talk offline. I left before I said something I would regret. I called a real attorney the next day and paid for an hour of his time. He does property and HOA law. He basically said, they cannot annex you without your consent unless the original CC&Rs on your parcel provide for that, and yours don't because you don't have any. If they try to lien you, it would be slander of title. Document everything, don't pay them a penny, keep all their notices, don't engage except in writing. If they trespass or harass, call the police. If they attempt to cloud your title, we can file a quiet title action and claim damages. He also said, some management companies try this as a pressure tactic when a developer sells phases and wants uniformity. I felt better, but the letters kept coming and then they put a yellow boot on my wife's car when it was parked on the street in front of our own house. There are no signs on our street that say HOA parking enforcement. The boot had a phone number and payment required $150 to release. We called the non-emergency police line. Well, the officer came and told the boot guy to remove it. The officer wrote a report and the boot guy said, we have authority from the HOA. The officer asked, is this street public? He said yes. The officer said, then you don't, and if you don't remove it now, I will arrest you for tampering with a vehicle. They removed it and left in a huff. I got their company name and took photos. The next day, a certified letter arrived, now with a list of violations: pets, non-approved exterior paint, non-approved mailbox, non-approved trash cans visible on trash day, landscaping non-conformance, I have tomato plants, and the original $2,000 levy now past due. Late fee added. It threatened a lien in 15 days. I am here because I want to do this right and not end up on the wrong side of some technicality. So I got the following questions for Reddit. Can I send a demand letter through a lawyer now, or do I need to wait for them to actually file something? Is there any advantage to front-loading a response? If they try to file a lien that references my parcel and title, what is the fastest way to get it removed? I've heard of expedited slander of title or a wrongful lien process in some states. Is that a thing? Is it worth filing a complaint with the state attorney general or real estate department? Is there a regulator for HOA management companies? Comment number 1. They cannot annex you, full stop. If there are no recorded CC&Rs on your parcel, you're not subject to their rules. Any lien they attempt to file is a wrongful lien. In many states, there are specific statutes that provide for damages and attorney fees for filing a wrongful lien. Send a preservation of evidence letter now and a demand to cease harassing communications. If they persist, hire counsel to file for a declaratory judgment and an injunction. Also, report the booting to your city. Private booting on public streets is not allowed in most places. And by the way, guys, before we read the next comment, what would you do if you were in OP's situation? Let me know in the comments, and while you're at it, please don't forget to post some star emojis and like the video if you want to support me, because your support is very much appreciated at the moment since YouTube is giving real voice readers a really hard time. Let me tell you, it's not easy to compete with the AI voice channels. Anyway, comment number 2, go to the county recorder's website, pull your legal description and parcel, and then pull every document that references your subdivision. Print the lack of CC&Rs along with an affidavit from the title company, if they will give you one. If they record anything, you can file a slander of title suit. Keep every envelope and the certified mail receipts too. Comment number 3, this is a scammy board. They probably think they can bluff you into compliance. Don't pay them a cent. Funnel all communication through a lawyer so they stop harassing you. Comment number 4, the boot company is likely breaking laws. Report them to the State Department of Public Safety or equivalent regulator. There are strict rules about signage and authority. Also consider filing a police report for attempted theft by extortion. Comment number 4, talk to your city council member. Sometimes the HOA likes to act like it owns the public street. The city will smack them. Comment number 6, fish or turtle only is the funniest thing I've read. Keep your dogs, they are bluffing, but do protect yourself. And by the way, guys, let me know in the comments whether you enjoy the legal advice stories or not. Either way, update, hey everyone, I took your advice. I retained the attorney I consulted. I know a lot of you say don't poke the bear, but the bear already booted my car. We sent a formal letter on his letterhead to the board and the management company, laying out in detail that my parcel is not subject to any CC&Rs, that any attempt to record a lien would be a wrongful lien under specific state statutes, and that any further trespass would be reported, that the booting was illegal, and that all future contact should go through counsel. We of course also demanded copies of any documents they claim apply to me, including annexation documents, minutes of the meeting, and the board's authority. We actually gave them 10 days to respond. My attorney CC'd the management company's registered agent and, just for fun, the developer's general counsel because their name was on the CC&Rs for the other development. In parallel, I filed complaints. I filed with the State Attorney General Consumer Protection Division. I filed with the city about the booting company, and I filed with the real estate department because it turns out the management company has to be licensed. I emailed our city council member and attached the booting police report. I told my immediate neighbors what I was doing. I offered to share my lawyer's letter with anyone who wanted to use it as a template. A couple of folks took me up on it. One is a retired school teacher who had already paid the $2,000 levy and was too scared to ask for it back. That really lit a fire under me. I got her a copy of the AG complaint form and offered to help her fill it out. This is actually where the malicious compliance part started, although I didn't know it at the time. In the board's previous email, Mr. Boatshoes had said all communications must go through the board, and then we don't have to show you anything. Okay, cool, no problem. I took that literally. I stopped emailing, I stopped talking to them at all. Everything went through my attorney, and my attorney's letters included a request for all board communications be preserved for litigation, and we also asked for their insurance carrier information because they would need to notify their directors and officers' carrier. My attorney threw in a casual line about, "We are considering a class action based on your deceptive practices." He said sometimes that makes them panic enough to stop, but he also said we would follow through if they didn't. The board's response came on day 9. It was a short email from the board secretary, not the president. It said, "We disagree with your assertions." The board acted within its authority under Section 2.1 to expand the community boundaries and under Section 9.1 to ban pets. We will record liens on non-compliant properties, and your clients can pay or they can sell. They still provided no documents. They refused to provide minutes or annexation justification. They did not provide their insurer. They CC'd the management company, and my attorney sent another letter more forceful with citations. He included a draft of a complaint for declaratory judgment and wrongful lien that he said we would file if they recorded anything. He also sent a litigation hold letter to the management company's registered agent, and he set a deadline of 5 days. On day 12, I got an alert from the county recorder that a document had been recorded referencing my parcel. I set that alert up because of something a Reddit commenter recommended. My heart sank for a second and then I opened the PDF. It was a notice of assessment lien from HOA listing my parcel, stating I owe $2,200 plus late fees. It was signed by the board president and notarized by someone at the management company. So I called my attorney. He said, "Okay, they want to play. Time to file." We filed suit that afternoon. It was a complaint for declaratory judgment that I am not subject to their CC&Rs, for quiet title to remove the lien, for slander of title, for violation of the wrongful lien statute, for unfair and deceptive trade practices, and for trespass. We also filed an emergency motion for a temporary restraining order to stop them from recording any additional liens or taking any enforcement action. We had the exhibits, my deed, the recorder's documents showing no CC&Rs on my parcel, the HOA CC&Rs mapped to a different tract, the board emails, the police report for the boot, and screenshots of the Wix website with their fish or turtle rule. The judge granted a temporary restraining order ex parte that day and set a hearing a week later. The order basically said they could not file anything else against me pending the hearing. My attorney served them that night through a process server, who later told us the board president tried to refuse service and then told him to leave community property. The server said, "It's a public sidewalk," and left the papers in his hand. Meanwhile, the AG's office sent me a letter acknowledging my complaint, and an investigator called. I gave them everything. The city code enforcement called me about the boot company, and they opened an investigation. My city council member emailed and said that this was not the first complaint about this HOA acting outside their boundaries. He CC'd the city attorney, and he also asked if he could connect me with a reporter at a local paper who covers consumer scams. I said, "Let me check with my lawyer." My lawyer said to keep it low-key until after the hearing, but that we could talk to neighbors and help them file complaints. At the hearing, the HOA sent a lawyer, not the management company's in-house counsel, but a local firm that does general civil stuff. The lawyer looked like she had drawn the short straw. She argued that the board had authority under their CC&Rs to expand. My attorney said their CC&Rs bind only the lots within the recorded plat, and there's no provision to drag in unrelated parcels without the consent of those owners and a recorded instrument. He cited case law from our state. The judge seemed unimpressed with the HOA's position and asked their lawyer if they had any recorded document annexing my parcel. She said they had internal minutes, and the judge asked, "Do you have a recorded amendment?" She said no. The judge asked, "Do you have the consent of this property owner?" And she said, "They are part of the community." The judge raised an eyebrow and said, "That's not how property works. Temporary restraining order is converted to a preliminary injunction. Remove the lien by close of business in 5 days or show cause why you cannot, and provide the plaintiff with your insurance information and the names of your board members. We will set a case management conference for 90 days out." The board president was in the back of the courtroom in his boat shoes. He looked like he ate a lemon. After the hearing, he approached me and said, "You're making a mistake. We're just trying to elevate the neighborhood." I said, "You recorded a lien on my paid-off house." He said, "You could have avoided this by paying." My attorney pulled me away. The title company sent me a letter offering to assist with any clout on title. Apparently, they had also filed a complaint with the AG after I sent them the lien. The reporter called again. This time, my lawyer said we could give facts but not editorialize. The story ran a few days later with the headline, "HOA files lien against non-member homeowner, court issues injunction." The comments were a bloodbath. A couple of my neighbors reached out and said they had paid the levy and wanted to know how to get refunds. One neighbor said he had been told he couldn't put up a little free library because it apparently was not an approved structure. He doesn't live in the HOA either. The reporter said the management company declined to comment, and the board president said, "We have authority." The AG then sent the HOA and the management company a civil investigative demand for documents. I only know this because the AG investigator told me. He also told me, off the record, that they had multiple complaints and that the board might be in for a rough ride. Here's where the malicious compliance really paid off though. Remember how they said all communications must go through the board and then we don't have to show you anything? Well, they had been sending all notices by taping them to doors and using their Wix portal. My attorney kept all our communications strictly in writing and through proper channels. The litigation hold meant that they had to preserve everything, and the AG's demand meant that they had to turn over their emails and minutes. And because they refused to share their annexation minutes with us voluntarily, we subpoenaed them. We learned the annexation was literally a vote of the board members to invite adjacent streets to join, and then when some people paid, they declared it approved by the majority of paying members. They never recorded anything because they knew they couldn't. They also had emails where the board president said, "We will scare them with liens. Most will pay rather than fight." He called my neighbors holdouts and blight. One email from the management company person said, "We can put cars near the new model homes to show that we mean business." They knew the street was public. They did it anyway. We also learned that the pet ban came because one board member's kid had an allergy and a dog at a new construction home had allegedly barked at him once. The board discussion literally says, ban all pets except fish and turtles to avoid workarounds. There was no legal basis for this. The developer's lawyer, whom my attorney had CC'd early on, started to sniff around because the bad press was hurting sales. The developer sent the board a strongly worded letter telling them to stay in their lane and warning that their D&O insurance might not cover willful misconduct. We amended our complaint to add the management company as a defendant after we saw their fingerprints on the booting plan and the lien notarization. We also added a count under our state's consumer fraud statute. My attorney explained that if we could show this was a pattern against multiple homeowners, statutory damages and attorney fees were likely. I knocked on doors. I found 8 other homeowners on our street and the next one over who had gotten the same levy letter. 3 had paid, 2 had gotten liens recorded. We added them as co-plaintiffs. One was a retired school teacher and she cried when she signed the retainer. I'm not usually a crusader, but watching her sign under plaintiff made me feel like we were doing something tangible. The HOA's lawyer tried to settle. The offer was, "We will remove the lien and leave you alone if you drop the suit and sign a confidentiality agreement." My attorney asked them to include all co-plaintiffs and to agree to refund any payments and pay our attorney's fees. The HOA balked. They offered to remove the lien just on my property, but we declined. Discovery started. And by the way, guys, if you have watched this far into this XXL story, please don't forget to like the video and subscribe to the channel if you haven't already, because I post daily stories. Either way, their emails were a goldmine. The board president had written after the first article ran, "We need to crush this guy or everyone will stop paying." He also wrote, "Don't respond to his lawyer, respond to him directly so we can intimidate him." He had demanded that all communications go through the board, but we had already made it so all our communications went through counsel and we had a court order. When he ignored that and taped another notice to my door, we filed a motion for sanctions. The judge granted it and fined the HOA $1,000 payable to the court and warned them that further violations would be contempt. The judge also ordered that any communication to any plaintiff had to be in writing through counsel only. If they violated it again, the board members could be personally sanctioned. The boot company folded quickly after the city cited them. They admitted it in a letter that they should not have booted on a public street. The city fined them and suspended their permit. We added that letter to our defense. The AG's office filed a separate civil action against the HOA and the management company for unfair and deceptive practices and for filing wrongful liens. It included a request for a preliminary injunction to stop them from attempting to enforce their rules outside their boundaries. The AG asked for civil penalties and restitution to homeowners who paid under duress, and the AG also named the board president individually. The board president started to sweat. The developer quietly started pushing for board resignations, and I heard through the grapevine that their D&O insurer had reserved rights, meaning they might not cover a judgment for intentional acts. At that point, the HOA called a special meeting for members. I don't know what was said, but the next day the board secretary emailed our attorney to request a global settlement conference. My attorney said we would talk, but we were not gonna accept hush money. We wanted relief that applied to everyone they wronged, not just the people who had the time and money to fight. This is where the pro-revenge part started to take shape. My attorney asked me what outcome would be appropriate for me. I said number 1, remove all liens, number 2, refund all levies and fines collected from non-board members with interest, number 3, public apology, board resignations, management company terminated, donation to the local animal shelter and the amount of the fines they tried to collect for the pet ban, attorney's fees, a consent decree with the AG so this cannot happen again, and if possible, disband the HOA entirely. That last one was of course a pipe dream, but my attorney nodded and said, "Let's see." We mediated. The mediator was an older retired judge who did not have patience for any nonsense. The HOA's lawyer came with the board president and the board secretary, and the management company sent their COO. The AG sent a deputy AG. It was a zoo. The mediator split us into rooms. We made our demands, including the animal shelter donation. The HOA offered to remove liens and pay my attorney fees, and maybe refund the 3 co-plaintiffs who paid. The AG said that was not gonna cut it. The mediator carried messages back and forth. He came back once shaking his head and said, "They are not listening." He told them that their annexation theory was a fantasy and that a judge was gonna hammer them. He also told them that if they insisted on a confidentiality clause, the AG would walk and take them to trial in the public interest. The board president apparently said, "We cannot refund everyone. It will bankrupt us." The AG said that was their problem. At lunch, my attorney handed me copies of 2 emails that had just been produced. They were explosive. One was the board president telling the management company that he had recorded the lien on my parcel personally because the management company's attorney had dragged feet. He bragged about showing strength. The other was the management company COO telling the board that they could use standard form lien templates from our other properties and swap the track number and that nobody will check. They had literally cut and pasted from another HOA and slapped my parcel on it. My attorney's eyebrows went up and he whispered, "This is gonna end them." When we went back into the joint session, the AG laid out her terms. She said the state would require number 1, a consent judgment prohibiting the HOA and management company from enforcing any rules outside recorded boundaries ever again, with a $10,000 penalty per violation, restitution to all non-members who paid with interest, a civil penalty to the state, an independent audit, a requirement that the HOA hold new elections under a third-party monitor, and 12 months of compliance reporting, as well as the management company to be referred to their licensing board. My attorney then added our private demands: attorney fees for plaintiffs, damages for slander of title, damages for trespass, and the animal shelter donation. He also suggested the board president resign as part of the settlement and be barred from serving on any HOA board in the state for 5 years. We all watched the board president's face. He turned red and said, "This is outrageous." The mediator asked if they wanted to take a walk, and they took a walk. They took an hour. The management company COO came back pale. They asked if the animal shelter donation could be in-kind services. We said cash. They asked if the board president could stay, but the board secretary resigned. The AG said no. They asked if they could cap restitution, but the AG said no. They asked if they could keep it confidential, but the AG left. We adjourned without a deal, but with a clear path to trial. The next day, the developer's general counsel called my attorney and asked for a separate conversation. He said the developer was not a party, but they were concerned about reputational harm. He asked what it would take to make this go away, and my attorney repeated our terms with a new addition: disband the HOA if members vote to dissolve it. He said he couldn't agree to that because it was up to the members, but my attorney said, then maybe you should educate your members. A week later, the HOA held another special meeting and the developer's rep spoke. I know because a neighbor who lives in that development and hates the board sent me a shaky iPhone video. The developer's rep basically said, "We don't support what the board did. The board acted outside its authority and created legal liability. Our financing and insurance are in jeopardy. Members' assessments will go up to pay for this unless steps are taken." Then he laid out the settlement terms my attorney had demanded without naming me, including refunds, resignations, the animal shelter donation, and a vote to dissolve the HOA if members wanted it. He said, if you vote to dissolve, the developer will fund the transition to a maintenance district for the common areas, so the neighborhood doesn't turn into a weed patch. Let me tell you, the board president looked like he was chewing glass. 2 days later, the HOA's lawyer reached out. They agreed to our terms except the disbandment. We said fine, then we want a membership vote on dissolution, supervised by the AG's office with neutral election management, and they agreed. We drafted a global settlement with a consent judgment. It had all the good stuff, aka the injunction, restitution, fees, damages, a letter of apology signed by the board to be emailed to everyone they harassed, and of course, the animal shelter donation for $25,000. We picked the amount based on the levies we knew they had tried to collect, the resignation of the board president and secretary, and the termination of the management company for cause, the requirement that any new management company attend training, and the agreement to place dissolution on the next meeting agenda with a fair voting process. The AG signed off and we went back to court to present the consent judgment. The judge asked the board president if he understood, and he said yes through gritted teeth. The judge entered the judgment, and the lien on my house was removed that same day. The HOA sent a letter to everyone they had contacted, apologizing and acknowledging that they had no authority to annex our street, that their pet ban didn't apply to us, and that they were refunding money. The retired school teacher got a check for $2,000 plus interest, she brought me cookies, and I cried a little. The boot company sent a separate apology and a $150 check to my wife, the board president resigned, and the board secretary resigned too. The management company got a notice that their license was under investigation, and the AG announced the settlement publicly. The article was brutal. It quoted the fish or turtle rule, had a photo of my 2 dogs looking majestic and oblivious. But now for the delicious part, the HOA held the dissolution vote, and because of the settlement it had to be supervised. Neutral volunteers and a third-party election company ran it. The developer showed up and said they would fund a maintenance district for the lake and playground if the HOA dissolved. Members asked, what happens to our reserves? The answer was they would transfer to the maintenance district. The former board president tried to argue that without an HOA, lawn heights would climb and we would all be in chaos. Someone shouted, "Chaos is better than you!" The vote was not even close. They voted to dissolve and the AG's office smiled like a cat with a cream. The dissolution process took a minute because there's paperwork with the state and winding down, but they did it. They filed articles of dissolution and the maintenance district petition was circulated and adopted. The common areas got funded by a small line item on property tax bills for members of the former HOA at a lower rate than the HOA dues had been, no board, no CC&Rs, and the beige boxes could finally have tomato plants. We attended the last HOA meeting. It was 10 minutes long. The interim board voted to terminate all enforcement actions and close the bank account after cutting the checks for restitution and the animal shelter donation. After it was over, the AG filed a separate stipulation with the management company. Their license was suspended for 6 months and they had to pay a fine. The board president got named in the AG's press release and had to pay a small penalty personally too. There's a rumor that he put his house up for sale. If he lists it, I hope his new HOA bans boat shoes. And the next one is a fantastic malicious compliance story to round things off. It is titled, "No stickers on equipment? Bet." So, at my current job, warehouse, no public interaction, we all have pallet jacks. Not personal ones, but each of us has our own pallet jack that we use on a day-to-day basis. For over a year and a half, my pallet jack has had a sticker with my nickname on it. Between my 3 other coworkers and myself, we have an understanding and everyone uses the one that is theirs. That being said though, this has never been a problem and neither has the sticker on my pallet jack until we hired a maintenance guy. We will call him Dickhead or Richard P. Head. Richard P. Head decided that stickers on pallet jacks or any of the heavy equipment, those had Decepticon/Autobot emblems that a previous employee put on, were tacky and, according to him, unprofessional. Richard P. Head then started to remove the stickers on the equipment any chance he got. One day I came in and the sticker with my nickname was ripped off my pallet jack. Okay, no problem, just put another one on. Richard P. Head ripped that one off too one day when I was away from my area. Same deal, new sticker. A few days after, my supervisor calls me into the office and goes off on me about how maintenance has complete discretion over the equipment and how it looks, and that if Richard P. Head takes off a sticker, it needed to stay off. As a consequence for putting another sticker on the jack, I needed to remove it and any other stickers on there. You got it, boss. So here's what I did. I removed them, every single one. Warning labels? Gone. Weight limits? Gone. Brand name? Gone. Then I convinced my coworkers to do the same. The boss said no stickers on the equipment anymore. My boss has not spoken to me in a week and I can live with that. And yeah guys, thank you so much for watching. Please don't forget to hype the video and I will see you again tomorrow.